Hello. My name's Alvin. I'm the Mind the Bleed Medical Legal lead. And today, thank you very much for joining the webinar on the general data protection regulations that will be given by Dr. Prithviraj today. We'll wait for people to steadily join. It's for those of you who have been joining our lectures up until now, this is the final webinar that we will be broadcasting. Massive thank you to you guys, as well as massive thank you to Dr. Prithviraj and Dr. Ramjan for supporting us all this way. They've been a very integral part of this webinar series, so we're very grateful to them, and I hope it's been as enjoyable for you guys, the viewers, as well as for them. I've certainly enjoyed my time helping out with this and listening to all the feedback as well. So yeah, it's been a nice journey. Just a couple of ground rules as always. If you have any questions, this functions like a YouTube live, so please comment in the comment section, and when there is some time free, or when there's an opportune time, I will have I'll put the question forward to Dr. Prithviraj. Otherwise, there will be a feedback form at the end that you can complete, and that will generate the certificate of attendance. So please stay tuned till the end. I'll post the QR code on the screen so you guys can scan with your phones, and yeah, we'll take it from there. Okay, so set the scene. I shall swing it to you, Divesh.
Lovely. Thank you very much for the introduction, Alvin. As Alvin mentioned, my name is Divesh. I'm an intern on Medicolegal hospital, and I'll be conducting this session on. So just give me 1 second.
Yeah, if anyone, please let us know if you can see the screen as well. Lovely. Add the scene.
Great. Can everyone see that?
Yeah, so I can see. If you try full screen.
Perfect. Is that okay?
Okay. Yeah, perfect. All good from my side.
Great. So the aims and objectives of today's session is to understand how we apply GDPR in the healthcare setting, to gain an insight into what measures we can take to protect patient data, and to also understand what data breaches are and how we go about notifying regarding data breaches. So General Data Protection Regulation, or GDPR as it's more commonly known, outlines responsibilities of data handlers when it comes to processing personal information. Personal data can relate to any information which could be used to directly or indirectly. And GDPR was originally part of EU law, and within the 2018, it was then retained within UK law as the UK GDPR. So the UK has independence to review its obligations. So we'll start off with another one of questions that I commonly do in my sessions. So we'll give about 30 seconds for this question, and then we'll just go through what the correct answer is and then move forward from there. Great. So which of the following is not one of the key principles of GDPR? So the correct answer is D, unlimited data retention. So as we'll come on to in a second, the key principles of GDPR when it comes to data retention is that it is kept concise and just requiring purely the information that's needed. So I have outlined using this kind of flowchart the 7 principles that the GDPR abides by. If we go through each one in a bit of detail, just to provide a bit more clarity. So the first one is lawfulness. So lawfulness refers to identifying specific grounds for the requirement of processing personal data. When we say that it's lawful, it means that the data subject understands and complies, is able to fulfill a contract with an individual and to meet a legal obligation as well. So the data subject is fully aware about the need for and the reason why we are requiring the information. So the next one is purpose limitation. Now, purpose limitation looks at the data subject's understanding the reason for collecting their information, and to also importantly have expectations about what the organization in question aims to do with it. This is to ensure that the organization has and also the individual has some ownership over the information. Data minimization is the idea that only the minimum amount of data is needed to meet the purposes required by said organization. Accuracy. So as it suggests, the information that's provided needs to be kept as accurate as possible. And any opinions that the data subject may have should be stored as purely opinions as opposed to being misconstrued as fact. I think one example that I managed to come across was if, say, a data subject had an old address from before they moved houses, then keeping that information stored still means that it's accurate, provided that it's clearly labeled that that's historical data rather than current data. Storage limitation looks at data being kept for the duration defined within the original requirements. The organization has the responsibility to justify exactly what the time scale is, and also to act on or to review information that's more or that's older, as the general sort of assumption is that older data is more likely to be inaccurate and therefore will need updating. Integrity and confidentiality is a way of ensuring that data is kept securely and to minimize the likelihood that a data breach occurs. And if it does occur, that there's a process to recover the data, or at the very least prevent further harm from it. And finally, when we look at accountability, it effectively means that the organization who's handling the data takes full responsibility for holding the data and also how they're using the data as well. So types of data can range. So we've got things such as race and ethnicity, religious views, political opinions, even information like trade union membership and genetic data as well. And the data subject rights cover various aspects. So it covers right to access personal data, the right to be informed about any decisions made to that data, the right to rectification of any errors, the right to erasure of data, which is something that we'll come on to a bit later as to certain requirements or certain incidences where that right to erasure may be avoided. Right to restrict processing, right for the data to be made portable, right to object, and also right related to automated decision making. So the reason why GDPR matters in the healthcare setting is because patient data is very sensitive and very confidential. And healthcare professionals are legally and ethically duty bound to ensure that patient data is protected and used in compliance with the GDPR as per GMC's good medical practice. Breaches in data protection can be damaging both from the perspective of the patient trust, but also with regard to financial consequences, which we will come on to later. And ensuring data is responsibly managed is something that's a fundamental aspect of the growing trend towards digital medicine as well. So now for our next question. What is the main lawful basis for a hospital processing patient health records for direct clinical care? Okay, so the correct answer is option D. So we'll come on to lawful basis in the next few slides. But the main thing to consider with this is that one of the lawful basis is the impact on public interest and the safety of the public as well when it comes to healthcare. But I will cover this explanation in a bit more detail once we go through lawful basis so that it's a bit easier to conceptualize. So GDPR requirements in healthcare, so as mentioned before, there's lawful basis for processing, which means that organizations need to document very clearly how they will obtain consent and why data is needed for particular things. Data minimization, as we mentioned before, that data should only be collected for its intended purpose and deleted when no longer needed. Data should be protected well. And in the event of a data breach, then the Information Commissioner's Office, or ICO as it's more also known, as well as affected individuals need to be notified within 72 hours of a data breach. And data processing activities should be stored adequately. So coming on to lawful basis, it's effectively a requirement in order to process personal data. So processing is considered lawful if at least one of the following principles applies. So firstly, consent, if the data subject has given consent for processing, if the processing is necessary for a contract with the individual, if it's necessary for compliance with the law, then it's considered a legal obligation. If it's required to protect someone's life, then it becomes something of vital interest. If it's necessary to perform a task in public interest, as the question alluded to before, then it becomes a public task element. And finally, with legitimate interests, if the processing is necessary for the legitimate interests of the organization or for a separate third party. So, as mentioned in the previous slide, you need at least one lawful basis to apply, but deciding that ultimately depends on the specific purposes and the context of the processing which you are aiming to carry out. So I took this example from the ICO website just because it gave a relatively clear way of interpreting how you assess what's the correct lawful basis. So if you wanted to consider legitimate interests as the primary lawful basis, then that may be considered if you wish to keep control over the processing and take responsibility for demonstrating that it is in line with people's reasonable expectations. Alternatively, if you wanted to focus more on consent by the data subject or the individual, then that would be considered if there's a high preference towards giving people full control over and responsibility for their data. Now, the reason why deciding which lawful basis is most important earlier on is because it becomes a bit difficult if you select a certain lawful basis in the beginning and then suddenly the event changes, so then there now is a new purpose for processing the data. So if you wanted to then proceed, you'd have to make sure there's compliance with something called the purpose limitation principle, which dictates that personal data, where collected, must be specified, made explicit, and it must be underlined what legitimate purposes there are and should not be further processed in a way that is compatible with the original purpose. The ICO website has quite a good sort of template that can be used to assess whether previous and then new purposes are considered compatible. And then if consent for the new purpose can be acquired or if the new processing activity, again, is compatible with the original purpose. So lawful basis is something that needs to be established for pretty much most health and social care organizations. And that's based on Article 6 of the GDPR. For private practice, they can rely on Article 1B, where they rely on the processing being necessary for the performance of a contract, while NHS organizations and practitioners don't necessarily have a contractual arrangement with patients. So instead, they're held by Article 6(1)(e), where the data processing is required under public interest. And health and social care data is considered special category data. So it must also establish a condition from Article 9 for lawful processing. So special category data is considered basically a subset of data that is more sensitive and requires heightened protection as it relates to things like a person's racial or ethnic origin, their political opinions, religious beliefs, and so on and so forth. And this data could create significant risks to the individual's fundamental rights and freedoms. And when we talk about Article 9, specifically we're talking about Article 9(2)(h), which dictates that processing is necessary for the purposes of preventative or occupational medicine, for assessing the working capacity of the employee, medical diagnoses, and the provision of health or social care. So, as we discussed before, when it comes to the rights of the data subject, individuals have the right to erasure if personal data has been processed unlawfully, if there's no longer necessary purpose for it, or if the individual withdraws consent for its use. That being said, if there's a specific lawful basis of processing, then that lawful basis can sometimes override a data subject's right to claim for erasure of the data. So those circumstances apply if the lawful basis is necessary for public health reasons, for public interest, and if it's necessary for medical purposes as well. So I've used this template, or rather this framework from the ICO website, to just highlight what certain lawful basis and what rights data subjects have in accordance with that lawful basis. I would suggest going on their website because it explains this in a bit more detail, but it gives you an idea of exactly what lawful basis grants you certain rights and what don't. Now, shifting more towards data security measures, the whole point of the NHS having secure data environments is to ensure that patient records are safely shared across departments and to enhance care coordination whilst also making sure that it's safe. And they also implement incident response protocols as well to review data protection incidents, and they also implement a national data guardian standards to help supplement this as well. So moving on to our next question. A hospital is reviewing its information governance policy. Which of the following actions best aligns with GDPR and the National Data Guardian NDG data security standards? Great. So the correct answer is option C. So as we'll come on to in a second when we review the security standards, one of the key elements is for staff to maintain their awareness of how to enforce adequate data security measures and to also keep up to date with mandatory cyber awareness training as well. So I've listed the 10 here. Effectively, we just run through them quickly. So personal data should be handled, stored, and transmitted securely. As mentioned before, staff should understand what responsibilities they have under the data security standards. And to go along with that as well, they should have an appropriate understanding of information governance and about cybersecurity protocols as well. Only pay staff who require the specific personal data should have access for it, and access should subsequently be removed if it's not needed. There should be, or there ideally should be, a focus on recording past security breaches in order to evaluate them to see what went wrong and then implement changes in the future to prevent them from occurring, which ties in nicely with the sixth point about cyber attacks as well. And a continuity plan should be in place to respond to threats to data security. Only the supported operating systems and software should be used. And finally, IT suppliers themselves must also understand what their obligations are as data processors to enforce adequate data security measures. So again, the data that aims to be protected is the data that we've outlined before in the previous slide. So personal identifiable information, health and genetic data, biometric data, financial data, and insurance as well. So in terms of data storage, NHS England follows an in-place records management policy. So records are created, stored, and managed within authorized systems rather than being transferred to a single central location. And they ideally should be stored within a collaboration hub so that only authorized staff can access them. Staff are always encouraged to save records digitally. And if they are not able to and there's a paper file storage, then it must be kept secure, and it must also be tracked quite diligently as well. So we've just discussed a fair bit about GDPR. So what exactly happens if there's a failure to comply with GDPR? Well, there's several things. The first is regarding the financial implications. So organizations who are breaching GDPR are liable to paying a fine. So fines can be separated into two tiers. So tier one is for less severe violations. So for things like not having a proper record of processing activities or failing to appoint a data protection officer where required. And then you've got tier two for more severe violations. For example, unlawful processing of data and failing to honor data subject rights. So each of them carry their own financial cost. Aside from the financial implications, you also have the impact that it can have on patients. The loss of reputation and organization may suffer as a result. And then the fact that one incident may then predispose that particular organization to being under increased scrutiny in the future as well. So data breaches are security breaches which can cause destruction, loss, unauthorized disclosure, or access to data. And where data breaches occur, if they're accidental, then steps must be taken to avoid a repeat breach in the future. And where they're considered intentional, then that is effectively a criminal offense. So our next question, a hospital IT department discovers that a data breach involving patient records has occurred, potentially affecting several individuals. Which of the following best describes the correct action to take under GDPR? Great. So for this scenario-based question, the correct answer is option B. So we've alluded to this briefly before, but we'll explore it in a bit more detail. But when an incident happens, then the correct pathway is to investigate internally. And in certain situations, there needs to be a formal report made to the Information Commissioner's Office within 72 hours. Yeah, so as mentioned before, if there's a data breach, then you need to inform whichever concerned parties or individuals there are, as well as ICO. If a data breach is deemed high risk, then individuals may be informed before ICO is notified. Irrespective of whether you inform individuals or not, ICO must be notified unless it can be shown that there's unlikely to be any risk to rights and freedoms of the data subject. Of course, because not informing ICO is a deviation from the standard pathway, then it's imperative that a decision to do that must be documented and justified quite well. If in doubt, always contact ICO and then relay to them exactly what the incident was. Obviously, trying to keep information as anonymous as possible as well. So when declaring a data breach, certain information is key to include. So this includes the nature of the data breach, for instance, how many people were affected and what data records were compromised as a result, what the likely repercussions of the breach were, what measures have been undertaken to deal with the breach and the resulting adverse effects as well, and the contact details of the relevant data protection officer and other people who could provide more information on the incident. So depending on which country you're in, data breaches may be reported either using the Data Security and Protection Reporting Tool or the ICO Breach Reporting Tool. If a breach involves individuals in EEA countries, then the EU GDPR will also need to be consulted and engaged. ICO have a self-reporting page as well, so they have a self-assessment tool and examples of personal data breaches to help determine if reporting is needed. And again, as we've alluded to before with the financial implications, if there's a failure to notify ICO, then the seriousness of the breach will then be used to determine what fine can be applied to the organization. So I've used these two examples here just to highlight what different severity of breaches may sort of look like and how they could be interpreted as well. So if we look at example A hospital suffers a breach that results in accidental disclosure of patient records. There's likely to be a significant impact on the affected individuals because of the sensitivity of the data and their confidential medical details becoming known to others. This is likely to result in a higher risk to their rights and freedoms, so should be informed to ICO and also the individual in question. Conversely, if you look at the example B, a medical professional sends incorrect medical records to another healthcare professional, and they inform the sender immediately and delete the information securely. So comparing it to example A, it's unlikely to result in a risk to the rights and freedoms of the individual and wouldn't necessarily need to, and so they wouldn't necessarily need to be informed. Now, these are examples I've taken from the ICO website. What I would stress very strongly is, obviously, given the various repercussions that we've discussed earlier, a decision about not informing about a breach can carry a lot of weight. So what I would always advise is discuss with others, also discuss with your data protection officer and the Information Commissioner's Office as well, in order to safeguard and sort of protect yourself in this situation. So when it comes to our responsibilities, this is all very sort of self-explanatory things, but is something that is at the forefront of ensuring that we carry out data protection as best as we can. So things like accessing only the required amount of data, avoid discussing patient identifiable details, in public spaces, for instance, in lifts, in cafes, communicating using NHS encrypted channels, for instance, NHS email, locking away computer screens when not in use, for example, when using mobile computers during ward rounds, ensuring that if you were to see a patient who's in an isolated bay and you left the mobile computer in a distant location, that screen is turned off or computer locked. disposing of notes of patient information in confidential waste bins, and also being mindful of the possibility of carrying out a breach accidentally, for instance, when discussing cases on social media, whether it's for learning or other reasons. So that, in a nutshell, sort of concludes GDPR and various aspects of it related to principles, how we apply in the healthcare setting, and what measures we can take to protect patient data, and what we can do with regard to data breaches. And I've used several references ranging from the GDPR website itself to NHS England, and ICO is a very good place as well to go if you want a bit more information about the topics that we've discussed. So I'm just going to stop screen sharing, or I'll keep the screen sharing on actually in case there's any request to go back to previous slides. Do we have any questions at the moment?
Doesn't look like we have any questions at the moment, but Divesh, if you just stop the share for now, just so that if we do have any questions relating to the slides, then we can come back to it.
Sure.
But yeah, we'll keep an eye on the chat. I'm just going to put the QR code for feedback on the webinar, so feel free to fill in the feedback form. Anything you write, we do incorporate into the rest of our, well, actually, unfortunately, not into the rest of our webinars, as this is the last one, but for any future medical legal related series that we'll be doing at Mind the Bleep. So all feedback is very much appreciated. But no, thank you very much, Divesh. Once again, very in-depth lecture on GDPR principles. I hope this has been useful to yourself as well as the rest of the viewers. And I think, yeah, it's, as the GMC's good medical practice outlines, it's all broadly comes under the topic of confidentiality, one of the main pillars that defines our professionalism. So breaching this duty essentially does have financial implications, professional implications, as well as a deterioration in the patient-doctor relationship or patient-organizational relationship. So these are very significant things that you must be wary of. And as you highlighted towards the end, they can be very simple things. I'm sure many of us have experienced being on a ward round or being on a computer on call, leaving that logged in. I mean, maybe not overnight, but in the daytime, you have no idea who could be accessing that information as well as potentially on your account. And it's sort of going back to the classic sort of SJT question of patient notes left out. These are, in effect, breaches of confidentiality, as you don't know whose hands these may end up in and how the data may potentially be maliciously used. So very important that we're aware of these principles. And yeah, it's also our duty not only to maintain this, but to keep up the training as well. So your hospital will have online training, usually sort of every 1 or 2 years they'll renew. But you can access that at any point, go back through the principles and make sure that you are compliant with GDPR. To ensure that you're practicing safely and effectively. So yeah, and yes, of course, Divesh, very importantly, identify how we actually notify these breaches. I think this is something that's slightly overlooked. We are aware of these principles, but rarely know where to escalate these. So you'll have a data protection officer, usually locally, as well as you can contact the Information Commission's office as well if you have any doubts. If you have doubts relating a data breach, generally they're on the side of reporting it, or once again, access your local medical defense union or whatever one you've signed up to. They'll be more than obliged to help out. So yeah, let me just check if there are any other questions. No, it doesn't seem like we have any questions at the moment. So yeah, once again, feel free to fill out the feedback form, and thank you very much, Divesh, for the webinar. And we shall conclude this. Yeah, we shall conclude this today. Thank you very much for everyone joining. It's been a pleasure.